Welcome to the last session, the last plenary session. You're going to be going off into your small groups and doing your last skills-based practicum, and then we're going to hand out the certificates virtually to you all. This last section on victims' rights, sentencing recommendations, and victim impact statements, you all know this. You live this. You've been helping victims for years on this. You're going to truly shine on this last very important section. As a review, generally, if your tribe is not Tribal Law and Order Act compliant, the maximum sentence that a defendant can receive for each crime is up to 1 year of incarceration per crime and up to $5,000 fine per crime. These can be maxed and stacked, meaning that someone can get a sentence of 11 months for domestic violence assault, 11 months for kidnapping, 11 months for stalking, and theoretically a tribal court judge could put those sentences end upon end, and the defendant could have to serve 33 months for all three of those crimes. Tribal courts can sentence a defendant who's been arrested and maybe they spent 1 or 2 nights in jail or a weekend in jail before they got bailed out or bonded out. The defendant at sentencing could be sentenced to time served, the amount of time that he's already spent incarcerated. Defendants could be sentenced by tribal court judges for a period of probation. They can also be sentenced to a period of incarceration, such as serve 30 days and then do 11 months of probation. They can just be sentenced to a term of incarceration. You're going to do 6 months in the tribal detention center, with or without the possibility of early release, also known as parole sometimes. And then tribes can be very creative in how they sentence people to incarceration. Sometimes people can be sentenced to house arrest with an ankle bracelet. Sometimes they have the defendant, if he's employed and he's the sole source of support for his family, sometimes a tribal court judge could order a defendant just to serve evenings and weekends. So they sleep in the tribal jail, they get up and they shower and have breakfast. Then they go into their job with the tribe or wherever they work and then come back and spend their entire evening and the entire sentence when they're not working in the tribal detention center. Something else that you can ask a tribal court judge to order is for restitution for her losses. You've got to have documentation, so receipts, or sometimes you can have affidavits. So let's say you had a ceremony for the victim and you had to buy food and paper plates and gifts, right? You would have those receipts and then you could submit those to the court and ask as part of the defendant's sentencing that he reimburse the victim for her lost wages, for money that she spent, let's say to replace the ripped blouse, to pay for childcare when she had to go to court, right? And the restitution that the judge can order can be either monetary. So if the value of her missed work or the gas that she had to put in her car, replaced items that were damaged, right? So he can say that's $1,236 I order the defendant to pay. But in a lot of tribes, there's high unemployment and it can be difficult to try to come up with that kind of money. So sometimes judges can do like an exchange of labor or of goods. So sometimes tribal court judges will say, you committed an act of domestic violence, surely has some very valid damages that require restitution, and we're going to have you provide a fully dressed deer and freezer space for her for the next year, or you're gonna dig an irrigation ditch for her, or let her use your backhoe with her brother. You can do some kind of trade, but one of the issues is you want to make sure that it's safe. So if there's a stay away order, if he's physically, mentally, spiritually, and emotionally abusing Shirley, maybe you don't want him to come by and stock her freezer or do repairs. Maybe it's too dangerous, right? So you want to think creatively, expansively, and safely. And then also think about what people did traditionally in your communities. if they wanted to make amends and they wanted to make things right and they wanted to make a victim whole. Tribes in criminal cases have the ability, you have to check your constitution and check your laws, but generally tribes have the ability to banish or exclude people who've been convicted of crimes on their tribal lands. Some tribes don't allow that for tribal citizens, only allow that for non-Indians or citizens from other tribes, so you want to check your code. And some tribes are getting really creative. As part of a criminal sentence, they're asking the judge to remove the licensure, the licensing of the defendant. So let's say the person is works at Head Start and they have a conviction for child sexual abuse. You could ask the judge to issue a sentence that prevents them from ever holding a position working with children for the tribe. You could also, if the person has a business license with the tribe, you could theoretically, if let's say it's an employer who sexually abuses an employee and they have a business license, you could ask the tribal court, if they have the power to do so, to revoke that license of that person's business as part of their punishment. And you can get really creative about that. We have that book that we had assigned to you to read, Creative Civil Remedies Against Non-Indian Offenders. If you've got any kind of interesting creative remedies, let me know. I'm always really excited to learn about that and to share them. So every state in the United States has some form of victim rights. Tribes are beginning to formally adopt these codes. Every tribe that I've ever come in contact with has, as part of your custom and tradition, some way that people who have been hurt or wronged, that they can be supported and they can have their voice heard. So if you find out how people traditionally supported victims in your community, you can use that as part of your victim impact statement. In general, before the defendant gets his final sentence from the court, the victim has the ability to tell the court, the decider on what the sentence is going to be, what it is that she wants, how it impacted her, this crime, what she wants to have happen to the defendant in order to make her as whole as possible, what kind of accountability they want imposed upon the offender. So any victim of a violent crime in state and federal courts has this right. And I would submit that in tribal courts as well, it is part of your custom and tradition, whether or not you have a formal code. And there are some good victim rights codes out there from different tribes that you can look at, so you don't have to reinvent the wheel, or you can call the Victims' Rights Law Center or contact us and we can give you some pointers on what a really good, vigorous victim rights statement might look at. But you have the right to be able to go do this, to tell the court before the court imposes the sentence, what is it that you want to have happen? What is justice? What do you think is fair? What would help the victim along on her healing journey? Now, this is completely optional. It's not mandatory, but it can be really empowering and impactful for victims to go do this. I can tell you that a lot of victims say, it didn't matter that they just got 30 days, the defendant just got 30 days in jail. What mattered was that they were able to go into court in a safe space and speak their truth out loud and have people listen to them and take into account their words, and then have the defendant, their perpetrator, be forced to listen to them. So it can be a really powerful experience for victims. And I can talk to you in this section about different ways that you can empower victims so that they can have their voices heard and you can have a more fair and just sentence that's imposed by the tribal court judge. So a victim impact statement is generally written to describe what it is that happened to the victim, any concerns that they have about their security and safety, what they've had to do in order to change their life or their lifestyle, how it's impacted them. They have the ability to tell the judge what it is that they want imposed in order that the defendant take responsibility for his actions that caused the harm and loss to the victim, and how is it they could be made whole as much as possible. So why do you write a victim impact statement? So I've been a lawyer for like more than 30 years. It's because they really work. That judges are actually human and they will actually listen to the victim. And sometimes, like in states like in Arizona where I live, judges are elected. And so this is their constituency, our victims and their families, and they vote. So they want to listen to the victim. The prosecutor represents the tribe or the state or the feds. The prosecutor doesn't represent the victim. That's why we're encouraging you to become the victim rights representative. You have that right under federal law. All victims have the right to a representative, to tell the powers that be, the prosecutors and the courts, to assist them in telling those powers what it is that they want to have happen. In most state courts, the victim has that right also to be represented by an attorney or a representative who could be an attorney or could be a victim advocate, and make their voice heard, to share their feelings, share their experience, and to ask for really specific remedies that will help the victim along on her healing journey. So, it can be emotionally harrowing. I'm not going to lie to you. It could be emotionally harrowing. And sometimes victims don't want to deliver the victim impact statement on their own. It's perfectly fine for a victim to write up a victim impact statement and have it just submitted to the court in writing. It's fine if a victim wants to do a videotape because they feel safer in your office or in their home and you're videotaping them, and then you can pause, maybe it can be edited. Maybe they've got a favorite blanket or a pet, or they've got their little 2-year-old there. They can stroke their head and be able to talk in a calm way and be able to get this out. Or maybe they want you to deliver the victim impact statement, or their sister or their neighbor or somebody that they perceive as being strong and steady with a voice that will be able to capture the attention of the court and ensure justice for them. When you're writing a victim impact statement, either that you're going to be delivering verbally, the victim might be delivering this in open court, or maybe she's going to have a representative deliver it for her, or maybe she's going to draft a written statement. I'm going to give you a series of tips. And this is stuff that I've learned along the way and from talking to other folks who represent victims, things that we find are the most effective. You want to tell a good story. And one of the things I'm so impressed with all of you in this course is that your writing is excellent. Your writing is excellent. You capture the imagination of the listener and of the reader. That's what you want to do. You want to be able to use those same skills that you've used throughout this course, and you want to be able to tell a story about how it is that the violence impacted her. So we've got an example 1 and an example 2. So in example 2, this is a woman whose daughter who has been sexually assaulted, and it's really changed the daughter, who is now living in a facility for girls who are suffering with trauma and serious mental illness. So the first way is just, yes, you wake up and you think about your daughter, versus you wake up and everything reminds you about your daughter. Humanizing it, making the judge feel what it is that you feel, the tremendous sense of loss and the tremendous sense of pain. If you can do that effectively, if you can touch that judge's heart, you can get more justice for your victim. You can actually get remedies that are going to be helping her and her family. You don't have to write in fancy, flowering lawyer language. You can speak and write like a normal human being, and use phrases that you would use in your own language if you need to. It can be good to have somebody check your spelling and grammar, just run it through spell check. Ultimately, it really doesn't matter. If it's from the heart and it's powerful words, that's really what matters. Okay, so you can spell check and make sure it looks pretty if you've got something written up, but ultimately it has to just be powerful, strong words from the victim's heart and from her direct experience. Don't expect your victim impact statement to get the perpetrator to confess or apologize. Normally, the perpetrator's there in court when you're delivering the victim impact statement, and they might just be looking at their shoes the whole time or staring at a corner. But I've never seen a moment in court where a defendant jumped up and apologized and admitted to everything. The most I've ever seen is a defendant staring down at the floor and mumbling, I'm sorry," to himself. That's like the most I've ever seen happen at a sentencing. Don't vent your anger towards the offender or the court. Now, this seems so counterintuitive, especially if your victim has had long-standing abuse or sexual violence against her that has impacted her horribly. Of course she's angry. Of course she's mad about how she's been treated by justice systems and by the perpetrator. That's normal, right? That she is outraged and angry. And this might be the first time that she's in a safe space where there's all these lawyers and judges and a bailiff's there, and maybe there's tribal police are there, right? So no one's going to hurt her, no one's going to strangle her, no one's going to hit her, and she might feel like this is a safe place to vent anger, and it's righteous anger. However, in my 30 years, I have seen that judges will hold that against your victim. I don't know why they do that. They just do. So if you could be the noble, pained victim, the hurt and sad victim, but for some reason the righteously angry female victim, I don't know why. I don't know why. Is it sexism? I don't know why. But that doesn't really get you as far as you think it would get you, the righteous anger. So you'll develop your own style. You'll know what your own tribal court judges are like. Maybe they like it if you have a victim who's riled up and she tells it like it is and she demands what she wants, and that's what gains respect from the judge. If so, go for it. If not, if the judge likes somebody who is more sad than angry, then you might want to talk to your victim about that. Ultimately, it's your victim's moment. It's her decision. It's her story. It's her life. It's her children. It's her opportunity to tell her truth. So you don't want to rain on that. You don't want to dampen that down, but you do want to let her know what you think is going to be most effective for her to get an outcome that she's going to find to be the most just. It's really important not to ever write anything that isn't true or is hyperbolic. You definitely don't want to write something in your victim impact statement. And I've seen this so many times. That's why I keep saying this is victims will say things like, I hope he gets locked up. And then when he's in jail, I hope people do to him what he did to me, right? That could be an emotion that you could feel if you've spent, a decade being sexually and physically abused and emotionally abused and spiritually abused. However, the systems don't look kindly upon that. So if you can ask her or discuss with her about maybe editing that out or not mentioning wanting any kind of violence or death or retaliation against the defendant, my experience has been that courts will hold that against the victim. And what we're trying to do is keep our eyes on the prize and get remedies that are going to make her safer, healthier, healing, and for her children as well. I think it's important to tell your story in a way that touches the judge's soul. So I've listed a whole bunch of other factors that you can have her consider when she's writing her victim impact statement, either to deliver out loud or to deliver in writing, but how it's affected her. How has her life changed? Is she afraid to drive at night now? Is she afraid of going into town because of what happened in McDonald's, and it scared her that the Anglos, who were the managers and everything, immediately went after her and thought things were her fault. And so she's afraid, like, has she altered her life? What are her feelings about herself and about her children and about their future? Has she isolated herself from other people? Is she finding herself to be sad and having difficulty getting out of bed? Has she had to access counseling or to go into a 12-step program? Maybe she's had to go and do like join a woman's sweat and decided that she needs to do that as part of her healing. So how has it affected her emotionally? How has it affected her physically? Right? Did she lose a tooth, or maybe when she fell, she fractured her hip, and now it's difficult for her to walk. Or she's got PTSD and she has anxiety attacks, and then they can be crippling. You want to talk about any medical treatment that she received, any lingering effects of the injuries, and how and any costs that she had. Like maybe she needed some chiropractic that they didn't have at IHS, but they had a sliding scale chiropractor in town. She had to drive into town and go do these treatments once a week, and she had to pay $32 because that was what her copay was on the sliding scale. So you want to make sure that you talk about the emotional impact, the physical impact, and the spiritual impact as well, especially if that's going to be influential to the judge. In our fact pattern, we have some spiritual abuse in our fact pattern. And in some of the jurisdictions that I've practiced in, that's going to be like the immediate, like, you're out of here, Marvin. You're an evil, disgusting person who's fallen below the standard of what human beings are like, and nobody tolerates witchcraft around here. And just mentioning that is going to make the judge biased against the defendant and in favor of the victim. And so if there is spiritual abuse and you think that your court is open to it, you might want to mention that in your victim impact statement that's delivered orally or on video or in writing. One of the things that's important to remember is that the defendant's going to get a copy of the victim impact statement. He's entitled to it legally. You're going to give it to him if he's representing himself, or you're going to give it to his lawyer if he's got a lawyer, but he's going to see everything that you write. So victim, I think, is in the best position to determine how the abuser is likely to respond. So she should tell her story. She should speak her truth. She should ask for what she needs, but she should also remember that whatever she writes, he's going to get a copy of, and she should be incorporating his potential reactions into a safety plan. Something that's really important, right? She's going to be in the court. She's going to be able to say these things in front of him, but, right, how long is he going to spend in jail? If she says all of these things, what's going to happen if he spends 2 months in jail and then he's going to come out, and then what effect will that have on her? So we don't want to silence her. We don't want to shut her down. We want her to be able to speak her truth. We also want her to know that he's going to be there listening. For some offenders, it's a public shame, and it wounds them very deeply to have other people in public say these kinds of things. And so try to talk with her about that when you're doing safety planning for after the hearing. Victim impact statements, do they make a difference? Why, yes, they do. They make a huge difference. And I want to say you want to get it in early, as soon as possible. You should be working on your victim impact statement, like I would say, right after he's charged, after you have a bail, bond hearing, initial appearance, arraignment. I would start working on that victim impact statement. If you can articulate what harm was done to the victim and why what it is that happened to her was so bad and has such long-lasting effects on her and on the children, and what it is that you want to have happen to him, you want to have that discussion with your victim and make those decisions early on in the case, because that's going to influence plea agreements, it's going to influence conditions of release, it's going to influence sentencing, and you're going to want to get this victim impact statement in as close in time to when either he's found guilty at trial or after he takes a plea agreement. Sometimes it's 30 days, sometimes it's 6 weeks, 2 months from the time that he's found guilty, either through a plea agreement or at trial before the sentencing. But let's say you have 30 days. There's going to be a pre-sentence report writer sometimes, right? Sometimes that can be your probation officer. Sometimes it's someone in the prosecutor's office. Sometimes it's the prosecutor himself or herself. You want to get in early and influence them with your victim impact statement, because judges are human, prosecutors are human, probation pre-sentence report writers are human. We want to get in and we want to have them biased in favor of the victim, against the perpetrator, biased in favor of recommending to the trier of fact, the judge, a sentence that the victim thinks is going to be the safest and the most just for her. So you're going to do this victim impact statement. You're going to have an eye on it immediately, right? She's got criminal proceedings against the perpetrator. You're going to be thinking about what the possible sentence is. What is it that she wants? Does she want him to just have some kind of work release because they need the money and he's got to pay child support? What it is that she wants. Start collecting all of your receipts. Try to figure out how you're going to want to deliver it. Sometimes you can have a written statement that the victim just reads, or her victim representative reads, or you can ask the prosecutor to read that. Okay, so there's a lot of different ways to be able to deliver a written statement, or you can just hand it into the court. You just want to make sure that you get it in well in advance of the sentencing hearing. If the sentencing's on Monday and you're turning in the victim impact statement on Friday, it is too late and you have just cut off at the knees all of your really, really hard work. If the sentencing is on a Monday, the very latest you should ever have it in is the Monday before. Absolutely. So if you're getting it in at the last minute, it's better to have something that's not perfect, but that's submitted in a timely manner that has hits all the high points, than to try to make something that's absolutely perfect and get it in the Thursday or Friday before the sentencing hearing. Now, some people make videotape statements. Every jurisdiction I've ever seen allows a videotape statement. If you could do it on your iPhone, you can do it on your camera, you can have students from a nearby college or university or your high school kids videotape, and you can have them edit. One of the reasons why you would want to do a videotape statement is because it can be really impactful if you've got a victim, especially if they don't write very well, and you want them to maybe they can display injuries that wouldn't show up if you had just a written statement. Maybe the judge wants to see them in their traditional home wearing their traditional clothing, and so that they can see that it's nice and neat and clean, and even though it's a dirt floor, it's a beautiful, loving home. So that would be another reason why maybe you'd want to have a videotape in. If you're going to be doing a videotape statement, find out in what format the court and or prosecutor and or pre-sentence report writer would like it in, because for security purposes, they might not want to put your jump drive in their laptop or in their desktop. They may want to have it be uploaded to a third-party site where they can view it. So you want to find that as well. If you're going to do a videotape statement, what format and how would they like to view this? Again, you want to do this, get this in quickly. If you've got 30 days before sentencing, I would get this in 2 weeks early. That's what I would do. And make sure that you've done all this hard work and people are going to see it and embrace it. So we're going to talk about the different things that you can ask for, right? One of the things that you can ask for, or one of the things that the judge can order, right, after the person has been convicted at trial or they've taken a plea agreement, is the judge can sentence them to a term of probation. It can be supervised or unsupervised. Supervised is there's going to be someone from the court, sometimes it's prosecutor's office, most likely it's someone from the court, who is going to make sure that if the judge says they've got to be home after 8 o'clock at night and they can't leave the home until sunrise the next morning, and then they might do spot checks on them, or make sure if a condition of probation is that they hold a job or go to AA meetings, there'll be somebody who either the defendant has to who's convicted has to report in and make sure that they prove that they are compliant, or sometimes they'll just spot check them. These are some very common terms for probation, and probation can be imposed with or without a term of incarceration in tribal courts, also in state courts and in federal courts. So the maximum sentence in most tribal courts is up to 1 year in jail. A lot of tribal courts do it this way. They'll say, okay, I'm going to impose a term of incarceration of 11 months in the tribal jail. However, I'm going to suspend 10 months of it and place you on probation for that amount of time. So you're going to serve 30 days. We're going to release you on probation. If you complete those extra 10 months with no problems, then we're going to just like let you go and say, you're done, get out of here, right? But if you violate for any reason, we're yanking you back in jail. Probation can also be for like more than a year. So you could have somebody sentenced to 6 months in the tribal correctional facility, in the tribal jail, and then 2 years of probation, if that's what the judge thinks would be safest for the victim and for the community. Some of the things that victims have found that keep them really safe are detailed no contact language. So a lot of courts will say, stay within 400, stay away 400 feet away from the victim. And then you have these squirrely defendants who will be like, no, I was 412 feet away. You want to make sure that you list the places, like in your protection order. This would be a criminal protection order in the criminal case as part of the sentencing, right? So you would get a criminal protection order as part of the conditions of release. You can ask the judge for a criminal protection order there. You can also ask the judge to update the criminal protection order or to issue a criminal protection order as part of the sentencing. And so you can say, we want to have a no contact order as a criminal protection order, and we want these provisions: stay away from the school, stay away from the church, stay away from the place of employment, supervised visitation with the children, all of those things, attend anger management or a batter intervention program, right? And there's all kinds of other things that you can request in a criminal protection order, in a civil protection order, and is also part of your sentencing hearing. Okay, so think broadly about what would keep the victim safe, and you can ask the judge as part of the criminal case sentencing to impose those provisions as part of the sentencing. And remember, protection orders you can file civilly. The victim can be the plaintiff and file for a civil protection order. And also in a criminal case, if the abuser is charged criminally, then you have the prosecutor or the victim can ask, or you as the victim's representative can ask the judge in the criminal case to issue a criminal protection order that the victim can keep a copy of, right? And it's enforceable in all jurisdictions in the United States. A lot of tribes place people on probation rather than incarcerating them. And there's a lot of different reasons for it. Part of it is the cost of it. It can be $70 to $150 a day to incarcerate somebody. Tribes might not have access to jails and to jail cells, or they're having to rent it from the county, or it's too hard on the families to have him incarcerated when they need his money from his employment. So there is a big push lately I've seen towards ankle monitors, electronic monitoring, as opposed to incarcerating defendants in tribal jails. I've listed a whole bunch of things that usually happen when someone is on probation. One of the things that I think it's important to note is this last one, which is violation equals revocation. So this is part of the beauty of a criminal conviction at trial, or the defendant taking a plea agreement in a criminal case. One of the wonderful things is the judge, when she sentences him, right, she can place him on a period of incarceration, right, and then also place him on probation, or just place him on probation. But any violation, you just call up the probation officer, call him up, or parole officer if he's sentenced to federal or state prison, and you say, look, he is not supposed to be at the kid's school, and he's not supposed to have contact, and then he was there, you know, at the high school baseball game in the stands, and, you know, mad doggy me and make, right? You could call the probation officer or the parole officer right there from the stands and say, he's here, he's not supposed to be here. And then they can come and then they can arrest him, put him in jail, and then he would have a probation revocation hearing whereby the judge will decide, okay, am I going to continue him on probation? Maybe he's on regular probation. I'm going to put him on intensive probation with more restrictions on where he can be and what he can do and what he's forced to do and has to prove that he's doing. Or maybe we're just sick of this and he just needs to go and be incarcerated now. So in some ways, it's really good if someone is on probation or on parole, they've been convicted, there's this criminal protection order against them, you've got sentencing provisions that restrict him, you just snitch him off. And then the probation, right, you don't have to file anything, the probation officer is the one who files things. So that can be really effective at keeping the victim safe. And if you've got an abuser who's getting a little empowered and out of custody and starting to exhibit dangerous behavior, that's a way to be able to yank him back and get some control over him. You can call the probation officer if you want to. If you've got the probation officer's phone number, you can just call 911 or dispatch and say, hi, there is a guy named Marvin and he is in the stands at the baseball game and he's part of his sentence is that he can't go to the school and he can't have contact with his son and he's here. It's a violation of protection order. You could call the police and do that. You could call the prosecutor at her office and say, hey, prosecutor, Marvin's violating the terms and condition of his probation, right? You could, on your own, you could file something. The victim or her victim's rights representative could file a motion with the court. Now, this is a little bit controversial. In most states and with the feds, you'd be able to file this because tribes, a lot of them don't have codes on victim rights. You're going to be the trailblazer and they're going to be like, hey, what is this piece of paper that you're filing? I didn't understand that victims are filing paper. This is confusing to me. And then you'd have to, you know, do your whole history of victim rights and custom and tradition and all 50 states and the feds and tribes are just, you know, starting to codify it, but it's part of your custom and tradition from time immemorial. You might have to get on that one. But you could file something with the court. So you can call the probation officer, right, who generally works for the court. You could file something with the court yourself. You could talk to the prosecutor. You could call the cops on them. And these are all things that can snitch him off for violating his terms and condition of probation or parole or release, right? It can also result in new crimes being filed against him. So in many jurisdictions, if you're on probation or you're on parole and then you commit a new crime, you have an enhanced sentence. The judge has the power to throw the book at you, right? So let's say that you commit domestic violence assault and you get sentenced to 30 days in tribal jail, and then you've got 3 months of probation. If you commit another act of domestic violence while you're out of jail, or you violate the protection order while you're out of jail, that can be a whole new crime. So if Marvin slashes her tires, he's not supposed to have any contact with her, he's not supposed to commit any new crimes. That's a new crime. He's violated the protection order, so he could be charged with that as a crime in your jurisdiction. If you've got violation of her protection order as a separate crime, which most states have, a lot of tribes are moving towards that. It can also be a new crime, which is the vandalism or property damage for slashing the tires. It can also be a probation or parole violation that just gets him immediately yanked in. So if you've got a victim, he's been convicted at trial or by taking a plea agreement, he's on probation, he's on parole, he violates any of the conditions of release, you want to snitch him off and you want to do it quick, okay? And there's a lot of different ways that you can do it. So parole, I've been talking about probation and parole. A lot of these terms are used interchangeably in Indian country. On the state side, generally, parole happens when you're let out of prison. So in federal court and in state court, parole is something you're sentenced to prison and then you're paroled. If you're sentenced to the county jail, or the local jail, and then you're let out. It's called probation and probation monitoring. Okay, so find out what terms your jurisdiction uses. Predominantly, if they've been to a state or federal prison, it's called parole. Sometimes I've heard these terms used interchangeably in Indian country. If you violate your parole, it's the same like violating your terms of probation, right? They yank you, they drag you back in, there's a hearing. At that hearing, the victim is entitled to testify at a parole hearing or at a probation hearing if there is a violation, especially if it concerned her. So if he slashed her tires, if he had contact with her or with the kids, right? So if or let's say Marvin is convicted of pistol whipping Shirley and goes to prison for a year, and they let him out after 10 months for good behavior, and then he's out for 2 weeks, and then he starts stalking Shirley. Clearly, if you snitch him off to his parole officer, they will hopefully pick him up, put him back in, and then he'll have a hearing where Shirley is able to testify, or you as her victim representative can testify about the underlying crime and how that impacted her feeling of safety while he was incarcerated. Then he was released, he started stalking her, how that made her feel, and why it is that she feels that he needs to be returned into custody in order to be able to have greater safety. So you got this, folks. You've got this. You couldn't even get into this class unless you were experts on domestic and sexual violence and had worked with American Indian, Alaska Native women who are survivors. You understand how it affects your victims and how it affects their children and your communities. And so you just need to open up your hearts, and you need to empower her to be able to do these victim impact statements, to get them in early, to make sure that the court hears how it's affected her. Now, some of you know the Office of Violence Against Women has this amazing graduate of the National Tribal Trial College who is a program manager for the United States Department of Justice Office on Violence Against Women. Her name is Rebecca Jones. And Rebecca is an amazing woman. And while she was going through this course, this very course that you're in, halfway through the course, her father was murdered. And she and her sister had to write a victim impact statement that was delivered to the court right around this time. Her sister delivered the victim impact statement to the court in Oregon, and the Portland Oregonian, which is the major newspaper in Oregon, they were able to videotape the victim impact statement that Rebecca and her sister Rachel wrote for the sentencing hearing of their cousin who had murdered their father. So I'd like you to watch this, even though it'll make you cry, and it makes me cry, because I love both of these women and their family. And this kind of a horror is just unimaginable. But the strength that they had in drafting this victim impact statement, the bravery of Rachel, Rebecca's sister, in delivering it is just so touching. So they've given us permission to show this to you. This is them delivering it verbally, orally at the actual sentencing hearing, and the written statement was given to the judge and the writer of the pre-sentence report in advance. So I'm going to leave you with their powerful words, and I'm going to leave you with my tremendous gratitude for having spent the past several months during a pandemic, during this time of tremendous change. I thank you for the time that you've spent with all of us. And I wish you great success for yourself, for your families, for your communities, for your people. And I want to let you know that we're here for you. I'm here for you. We're all here for you. That it doesn't end here. That we're going to continue to fight the good fight to try to help each other and empower one another. And I'm going to leave you with the powerful words of Rachel and Rebecca. And we'll see you on the other end of this after you've done your small sections, skill building sessions. And we're going to give out your certificates. I'm so honored to have been a part of this with you. Thank you so much.
So I'm reading this statement on behalf of my sister, Rebecca Jones, who's on the phone and could not be here. Your Honor, despite how difficult it is for me to speak here today, I thank you for the opportunity to speak on behalf of my father and my family at this time. My statement will be short, but I really feel I need to say something. Our father was a good man. He was selfless and gentle. He always chose peace and to live and not leave. He was the most accepting man I ever knew. He accepted everyone, no matter where they were in life. He accepted them as they were, for who they were. He always tried to help out everyone, but especially his family. Growing up in poverty, he knew the struggle to survive day to day. When he and my mom married, we constantly had family members moving in from South Dakota to live with us, to try to make a better life for themselves and their children. Even Matthew, as a baby, moved from South Dakota to live with us so that he could potentially have a better life. At one point, we had 22 people living in a 5-bedroom house with 1 bathroom. My mom and dad supporting all of those people as they looked for work or went to school. His generosity knew no bounds. If someone needed a shirt off of his back and the last $5, he would give it to them willingly and with a smile on his face saying, "Have a nice day." He taught us girls well. Our dad was a survivor. His life was in jeopardy numerous times. He had a massive heart attack in his 30s. He was in a rollover car wreck that broke his neck in 2 places and his back in 3 places. He suffered beatings when he lived on the street, but he always survived. Injuries that should have killed him, he survived until the last one, and that's what makes this so hard to make sense of it. It's what makes this so hard to come to terms with. After everything that he has survived, it is his own family, the family that he would do anything for, that no request was ever too big. It was his own family that killed him. The last year since our dad was murdered, it has been incredibly difficult. Sleepless nights, long, hard, tear-filled days, questioning faith and trust, not strangers, but family members, the people that you're supposed to be able to trust unquestionably. Matthew killed our dad. He's made me question if I can trust our family. And if I can't trust family, who can I trust? Even beyond that, watching my youngest sister walk through hell has been heart-wrenching. I've been concerned for her life and the life of her son on several occasions since my dad's murder. I have seen her spiral into the depths of her addiction to the point that my nephew couldn't live with her anymore, and I seriously thought that she might die or end up in prison herself. My nephew had to go live with his father over 1,800 miles away just to assure his safety and to afford her the opportunity to grieve and get her life back on track. Through prayer and her hard work, however, she's doing better. We are all doing better. This will not break us. If anything, this has made our little family stronger, and we are keeping our little circle close. Thank you for your time, Your Honor. Rebecca Jones.